Good morning, everyone. For those who didn't meet me yesterday, my name is Emily Stokes-Rees, and I'm the Interim Director of the School of Design at Syracuse University and a professor in the graduate program in Museum Studies. I'd just like to take a moment to remind all participants that live captioning is available and also that every session is going to be recorded for future viewing. We've already had many requests for the videos, and so we just ask for your patience as we edit and prepare them, and they will be made available to all registered participants in the weeks to come. Please feel free to use the Q&A function to ask questions. As in other sessions, due to the number of participants, it's likely that we won't be able to get to all of them, but we will do our best to address as many as we can. An important announcement to note, there are 3 concurrent breakout sessions coming up next, and each session has their own dedicated link that you'll find in the program. So for the only time in this symposium, you'll have to make a choice of which session you'd like to attend. I'm pleased to be the moderator of this session, Ask the Lawyers. The focus of this session is to allow the audience to pose their toughest questions to our panel of lawyers on collections, de-accessioning, governance, intellectual property, or anything else on your mind. I'm looking forward to a great discussion. Before we bombard them with questions, however, allow me to introduce our panel. Frye is the Spears Gilbert Professor of Law at the University of Kentucky College of Law, where he teaches courses in intellectual property, copyright, trademark, nonprofit organizations, and professional responsibility. Mark Gold is a partner in the law firm of Smith, Green & Gold, and he represented the Berkshire Museum and the Everson Museum of Art in their recent de-accessionings. Donn Zaretsky practices art law in New York City, and on the side has been writing compulsively about de-accessioning for more than a decade on his blog, The Art Law Blog. Nicholas O'Donnell is a partner in the litigation department of Sullivan and the leader of the firm's art and museum law practice group. Welcome to all of you, and thank you so much for being here. So while we give everyone in the audience a moment or two to get their questions into the chat and to think of them, I'm going to use my moderator's privilege to get the conversation started. And I've got a question about public trust. So opponents to de-accessionings that go against the standards of the professional associations often claim that museums selling art for purposes outside of those standards have violated the public trust that requires them not to sell objects entrusted to them. So my questions around this are, who is the public in the public trust? And what are the actual kind of legal underpinnings of the term? If a work is sold from one museum to another museum, does that really count as a violation of the public trust?
Yeah, I mean, the argument is just not just wrong, but ludicrously wrong. Like there's literally nothing right about it. The public trust is a doctrine that relates to primarily public waterways and certain kinds of public lands. It has nothing to do with artwork, has no application to art museums or their collections, and people should really drop it already.
Yeah, I think I agree with that as well. I think that somewhere along the line, this phrase got inserted into the conversation, but if you push it a little, I agree with Brian, it doesn't make a lot of sense. And even the standard view, the AAMD view on de-accessioning kind of acknowledges that the works are not held in the public trust, because if they were held in the public trust, they couldn't be sold for any reason, including to buy more works of art. So I think nobody really takes it seriously. It's intended more as a metaphor. And I've had this thought before, I think Nick may disagree a little bit with that position, but I think that sometimes when people use the phrase, they don't really mean the public trust, they just mean a trust. Like if Nick, if you put some assets into a trust for your kids and you name me the trustee, it's supposed to capture the idea that I hold those assets, they don't really belong to me. They're for the benefit of your kids, and I have an obligation to take good care of them and not squander them. They're held in trust, not the public trust. But even that analogy breaks down too, because if I'm the trustee of the trust for your kids, the point is not for me to just hold on to those assets, right, while your kids starve, but to use them to take care of your kids, to pay for their college, to buy them a house, a car, if they get sick, to pay for medical care, to make their lives better. So if they find themselves in a financial crisis because of a once-in-a-generation pandemic, for example, and they turn to me for help, it wouldn't make any sense for me to say, I'm sorry, I can't help you. I hold these assets in trust for you. So, whether you think of it as the public trust, which as Brian said, really is a very limited, narrow doctrine under the law, or just as a metaphor for a trust, it doesn't do the work that I think opponents of de-accessioning or defenders of the standard view of de-accessioning want it to do.
So I'll play along a little bit. I think it's, I agree. It is an analogy and not a legal concept. A trust is a very specific thing where title to property is held by a trustee who is a person for the benefit of someone or something. And many museums, of course, are trusts, and they're charitable trusts. I can't quite speak to the etymology of it, but I think the reason it has gained currency, and I think more people find it useful. Donn and I might not agree about that, but I think it is intended to capture a concept, and that is museums are charitable institutions of one form or another, generally speaking, under state law. And as a result, they enjoy the benefit of certain treatment that private property in my hands doesn't. And what are the trade-offs for that? What is the public getting out of giving these institutions certain benefits, principally, I think, from a tax standpoint? And it's intended as an ethical matter to drive the conversation about what ought to be done or not to be done. So we're asking the lawyers here. I think we're all in agreement. It is not a legal restriction. It is not, in fact, a trust. And I think we've laid out sort of the degrees to which people find it useful or not.
So let me let me interject with kind of a follow-up question. And I'm kind of going a bit out of order in the questions as they've come in, but I think this one is really related. Somebody asks, I wonder then what term or phrase we actually should be using in the field to define our relationship or our responsibility with and to our communities.
I would say the important concept to my mind is the fiduciary duties of the directors of a charitable institution to the charitable purposes of an institution. And I think that's the right way to think about the way that an institution's duties to the public are going to be managed. And I think the problem is, at least to my mind, that the kind of public narrative or kind of big picture narrative around museum collection management has been misdirected, right? In the sense that people have directed their attention to the maintenance and coherence of the collection rather than the institution. And the duties of the people who manage a museum and are ultimately responsible for the collection of that museum run to the institution itself, not to the objects in the collection. And they do have legal duties, they do have fiduciary duties, but they have fiduciary duties to the organization, not to the collection. Now, of course, the collection is a reflection and a very significant part of the institution, which means they have to think about that when they think about what their fiduciary duties to the institution entail. But at the end of the day, the buck stops with the institution itself. And any sort of perspective that elevates the collection or rules managing or rules about how you're supposed to manage the collection over the institution itself, I think are wrong and arguably not actually consistent with the real legal duties of the people running the institution.
Yeah, I would follow on to what Brian just said. He's absolutely right. And that's been true for a long time. But I think the confluence of the pandemic calls for social justice, addressing diversity within the months of where we are, within a year certainly, has shown a bright light on the issue he describes. It is the boards have a fiduciary duty to weigh priorities and decide how their assets will be deployed. And it's shown a bright light on the primacy that's been afforded museums, or I'm sorry, collections for all these years. And I part of the symposium has also addressed this issue of collections play a role in mission, but mission is also fulfilled with programming, with well-paid and staff and appreciated staff. And it's much more than the collection. So, and I mean, that it's much more than the collection is my personal opinion. There are also people who are on these panels who still afford the collection primacy, its primacy, and that's a very important, legitimate perspective. But I think Brian's point is that has been just exploded during a pandemic with financial challenges, Black Lives Matter movement. It's shown a bright light on this very important decision-making, prioritizing process.
Can I add something to that? I think those are all well-taken points, and I think I agree, and it is absolutely true that a trustee's duty is to the institution as a fiduciary of it. But I do think that the pandemic, as part of this discussion about de-accessioning, also highlights that the question sometimes is more complicated than that, because you can view the collection as sort of something of primacy, as Mark just said, and people could agree or disagree about that. But even if you think, well, I'm not going to focus or fetishize a certain set of objects, I still think you need to unpack what does the institution mean with respect to its mission, right? Because to take an extreme example, if I have the Museum of Greater Boston and I conclude that I cannot continue financially, and I turn it into the Greater Boston Conference Center, but it's in the same building, right? Well, then I'm making a mockery of what my mission was. So I think, and I don't mean to be glib about that, I think there is this really hard tension, right? If I have no idea if these statistics are true, but if a meaningful percentage of museums faces the inability to continue because of the pandemic, and let's assume for the sake of the discussion that that is unavoidable. Okay, well then selling the art or selling anything isn't going to help them stay open. If that were true, or if some subset of those museums couldn't stay open even if they sold the art. Well, then the question is, if I'm a trustee, I have an obligation to something, and what is it, and what is it that I should do? Because it might not be as simple as just keeping the doors open at all costs, because that might not even work. And if it won't work, I'm not off the hook of the hard questions that follow. Then I still need to figure out what to do.
I think that's exactly right. Sorry, Brian, but exactly right. And that I would just say that, sale of any particular work of art may or may not be compatible with an institution's larger mission as the institution itself defines it. And the only way to know that is to look very closely at the individual facts and circumstances of each particular proposed sale, as opposed to adopting a bright line rule that says it would never be compatible with an institution's larger mission to sell a work of art. I think in terms of fulfilling a director's fiduciary obligations, the former approach is the better one.
Yeah, I mean, I would give it I mean, I agree with what Nick said, but as a practical matter, I give a counterexample. And the one that always kind of jumps out to me is the Concurrent institution, right? Because the trustees of the Concurrent institution had a fiduciary duty to the institution. And when it was in financial trouble, frankly, because in part because of their own bad decisions, they relied on AAMD rules to say that, well, our hands are tied, we just have to wind up and sell the entire institution rather than sell anything from the collection in order to keep it alive. I personally think that they could have kept the museum alive and the art school alive in its previously existing form if they wanted to, and they didn't. I personally think that was a breach of their fiduciary duty. I personally think it's scandalous that they weren't held to account for that. And I think that that's a kind of problem that, that we need to be aware of, right? And we need to think really long and hard about whether we think that that's an appropriate outcome in circumstances like that. Because I think there were institutional values that were lost in the name of preserving the integrity of a collection that ended up going, practically speaking, somewhere else anyway. So what exactly was accomplished with that?
So we've got some questions coming in, and I've got one here that sort of speaks to my heart. Many years ago, when I was a graduate student and I was first working part-time as a collections assistant in a museum that will remain nameless, this was one of my jobs, was dealing with the stuff that people left literally on the doorstep almost every night and figuring out what to do with it. So this question reads, unsolicited donations are among the lowest priorities for collections staff in my history museum, this person says who's writing, creating problems because of the time required to review, document, and dispose or try to return them. Can you speak to the legal requirements of museum property law regarding documentation for materials that museum staff maybe didn't request or didn't want in the first place? This was one that plagued me. I worried about throwing people's things out.
I think it goes back to the fiduciary duty concept.
Mhm.
I would say, I'm curious what the rest of you think, which is to say, the best exercise of your fiduciary duty is to have a clear and prospective acquisition and accessioning policy, and then to follow it. And so if someone offers you something or leaves something on the back steps, then consider it pursuant to a policy that you already have. Don't do an ad hoc consideration from there, because I think, we don't have the regulators anymore, but I think from the standpoint of attorneys general or charities divisions, if someone leaves you something and pursuant to your collections management policy, you conclude that it's inconsistent with your mission or not of sufficient quality or whatever else, and not to accession it, it's hard for me to think of how anyone would find fault with that.
Yeah, I agree with Nick 100%. I think the main problem to be concerned about would be something around a like self-dealing, right? Where, if you had collection managers saying, the museum doesn't really need this, but who does? I do, right? Like, I'm going to take it home with me and keep it myself. I think that would be a big problem. But making decisions about whether to keep or dispose of the materials, the materials, so long as the institution's interests are being put first, I don't see any legal problems with that at all.
Yeah, I agree with Nick too. And I have to say, I've never done an Ask the Lawyers program before where this has not come up. And often it's a very frequent question. Often these things are left in the middle of the night. They aren't it's just left on the doorstep in the middle of the night. And I think there's a practical answer. They say, well, what should I do with that? My answer generally is, well, call the police. I mean, we assume that whoever left it actually had title to it. And these can be things of value that someone has just abandoned. And I think that, certainly don't accession it unless you know all those things, but find out if this is just, if it really belongs to the person who left it, and that's not your job. You've got enough to do in a museum without trying to find out, fingerprinting the doorknob and everything else. So and as any normal, the museum is just like any other institution or person where something has been dropped on you. There's a responsibility to figure out, is that appropriate or not just say, should I keep it or should I throw it away?
Well, and that's a good point, Mark. And I would add to that, just for the benefit of the folks in the audience, who I don't have to say this to, that people are always offering things to museums thinking that of course the museum wants it. This is true when you do want it. And it is just as important in those circumstances to have those policies and procedures so that you ensure that the person offering the thing that you do want, in fact, has the right to give it to you. Because that's a real mess you don't want either.
Well, and along those lines, we've actually sort of got a kind of almost like a sister question here about gifts. And so the agreements that are drawn between museums and the people who give gifts to them. I'm just trying to edit a bit here. The question is, what is the responsibility of the museum to alert a donor or their descendants to a pending de-accession? What does that relationship look like?
I think usually there isn't going to be a legal obligation unless there is a conditional gift that says so. I think there are very good reasons to engage donors or donors' families in those conversations. And this is why I go back to, like I said, why I think the public trust is not a legal concept, and its utility can be debated, but it's part of a conversation that I do think is important ethically, which may or may not ever redound badly in a breach of fiduciary duty accusation, but is, I think, still good practice, which is to say, who gave this collection or set of objects, and how does that gift and that story play into our community and to the identity of this institution? That's important, I think, to cultivate future donors. It's important to the extent the story of the institution is worth telling, which I think usually is, and what is one of the wonderful things about museums is every museum's story is a little different. And that's one of the things I love about going to museums and being around them, is how differently they came to be. And so I think you do credit to the people who caused that to happen by engaging with them. Doesn't mean you need their permission. You may disagree with them, but you're less likely to have a public disagreement if you at least try to talk about it first.
And to connect that to the larger discussion and debate around de-accessioning, sometimes people say, well, if we allow the sort of broader de-accessioning for, other than to purchase more art, then no one will ever give works of art to a museum anymore. If that's true, one thing you can do is in your deed of gift, you can provide that the work cannot be de-accessioned, right? Most museums will accept that. Some will not agree to that, but many will. Or you can have them agree they won't de-accession during your lifetime, or that if they do want to de-accession, they'll give you notice or they'll consult with you. So there are things, if it's a concern of a donor, it's something that can be dealt with up front.
There's kind of a related question here, which is around a private citizen wanting a museum to store something from their personal collection. So either with permanent exhibition or by placing it in storage. And this person wants to know, is there actually a legal response that can help them kind of cut that off at the chase? Is there an out?
For the museum?
For the museum, yes. For requests to look after pieces of art from personal collections.
No, thank you. I mean, I think.
This is what I assume, yes. But I suppose the question is more, is there actually something, is there a legal response that they can kind of use?
I don't know of any prohibition. I think if you were looking for a rationale to say no, it could be, the traditional, the usual suspects of, oh, we can't take on the liability, we don't have the room. But more importantly, it's not, and which the potential donor may not understand, it's not part of our mission to be a warehouse. If we need this for an exhibition and you want to loan it to us, thank you. But if, we just have a nicer storage facility than you do, it's not for your art, it's for ours. So. Yeah, but I don't know of any prohibition from a museum doing that, unless they turned it into a business.
It's a public trust, it's not a public storage facility.
Being recorded, Donn. Well, and I will say there was one, let me scroll back here. There was one kind of more of a comment than a question related earlier to the public trust that then came in, which said, and I think, personally, I think this is largely the case. It says, do you think what people mean instead of public trust is really public access? Which is why people really don't like and find very troubling the idea of sales possibly going to a private owner. And so I thought that was a really interesting comment, because I think that could very likely be the case, that actually, for many communities, even if an item isn't on display, the knowledge that it is there and it is part of their, kind of community trust is what is important. They could see it if they wanted to. Sorry, let me scroll down here. We have questions coming in thick and fast.
I mean, I think there's something to that in terms of its explanatory value
Mhm.
as to why many people get upset about museums and museum boards making decisions about de-accessioning and collection management, which they just disagree with. That these are highly value laden decisions about what's important, what should be highlighted, what we should, expect to see in a museum collection. And, they have a lot of personal investment, I think, in the work that museums hold and what it means for that work to be in a museum and to be displayed by a museum. But I found that, and Mark kind of got to this earlier. Right? I mean, I've found that conversation to be a little impoverished at times, in the sense that it sort of tends to beg the question about what is valuable and should be in a museum and what shouldn't be. And I think that it really came to the fore in relation to the recent Baltimore Museum controversy, where the people who got upset about the museum's proposal to sell work just took it for granted that their beliefs about what was valuable and important should control the museum's decisions about what to keep and what to sell and how to manage its collection. And without ever really taking into account the fact that, the museum, I think, was legitimately and seriously trying to do the best it could to think about the needs of the community and how its collection would best reflect the nature of the community. And, I personally thought that their proposal was quite sensible and didn't seem particularly outrageous to me at all. And the idea that, that this should be some sort of like diversification with all deliberate speed, I mean, I don't know, man. I'm not really down with that.
Yeah, I think that's a great response. We have a number of questions here, and I'm going to try to kind of combine them. Regarding guidelines or and like kind of a best practices, best plans of action for smaller museums that maybe have had loans come in, historic loans from a long time ago. Some have completed paperwork. Some only, have listed in a notebook like permanent loan, which is one of my favorite phrases. And now they've been around, these objects have been around. Some of them are fairly big collections, 300, 500 pieces. And they don't have really sufficient provenance, that sort of thing. And what are best practices for museums who are dealing with a lot of these? Maybe they want to get rid of parts of the collections, maybe they want to get rid of all of it. What are ways forward for these smaller institutions?
I'm curious what the rest of you think, but I have had conversations with smaller museums where that center around essentially clarity about whether the object was in fact ever accessioned. And I've had situations where we just couldn't get to the bottom of, okay, this thing showed up here no later than date X. There's some reference to this family or whatever, but we really can't tell kind of what they meant to do with it. And I think arguably, I mean, there's a different question from, do you have the legal right to sell it? In which case you probably do. But I think you can draw distinctions. Certainly I've thought more about this in New York, as to whether it was ever accessioned and therefore the de-accessioning regents rules even apply.
And many of the states, I don't know if this is the issue you're talking about, the found in collections statutes that many states, I don't know if all states have them yet, but it's a variation on a theme and you could consult your own state statute as to, what are your legal requirements? Can you post a public notice to acquire title to this? What do you have to do to track down the heirs? And it's a very specific process that the end of which I think gives you title in order to dispose of it. But to Nick's point, I mean, there are two issues. One is, do you have the title to dispose of it? And then have you accessioned it into the collection? Neither of those are insurmountable, but they're separate topics. I mean, you can have title to it without having ever accessioned it, and that makes life a lot easier.
Thinking ahead to a panel later in the day on university museums, or what we're calling museums with parent organizations. There's kind of a different relationship and different layers in those museums, kind of authority. So I'm wondering if any of you have anything to say about kind of where is the institutional authority, boards of university museums, what power do they have to drive kind of decisions and policies and that sort of thing, and how, from a legal perspective, how do those relationships work?
Oh, I can take a shot at that if you want. I think there's a reason why so many of the controversial de-accessioning cases are university museums, and that is because these are for the university, which is governed by its board of trustees. The university museum is one academic resource among many. So, they might have advisory boards, but they don't have boards of trustees in a legal sense. They're the library, they're the academics, they're the research branches, they're all those things, and there's the museum. So the fiduciary duty of boards of trustees of academic institutions is to the academic institution and to deploy their resources among their academic tools, their vehicles, and the university is one. So as they do that, and even as they look at the art within the university museum, they say, well, there's a piece of art. Let's look at how that informs the scholarship that's going on in the museum versus taking that value and putting it into faculty salaries or a laboratory, and which is the best for our students to have this really valuable painting as an academic experience. And I'm saying this in a non-judgmental way. It is actually the process that they do. And that was on steroids with regard to Brandeis. And in 2009, if you look at what Brandeis thought they were going to have to give up to keep the Rose, it would have decimated their academic programming. And it was a very hard decision. It turns out that things changed and they didn't have to do that, thank goodness. But that was the hard decision that they make. So there's some really good work done by Lyndall King, who I saw at an AAM meeting years ago, on ways in which academic museums can actually endear themselves to their provosts and their presidents and the people and their board of trustees to posture themselves as important academic resources. But at the end of the day, there's no one there to protect them or their collections, absent the very high level governance of the university. I think there was another interesting thing in AAM's accreditation process years ago. They required the boards of parent organizations to adopt essentially a hands-off approach to academic museums collections. And apparently a lot of university boards did that. And it was part of the accreditation process, as I understand it, for those academic museums. But at the end of the day, it's like anything else. If the university board believes the institution is in trouble, it won't really matter that 15 years earlier they said that they weren't going to go after objects in the collection. But it's there, and it's an important reminder. But yeah, I think that's why. To my view, that's the perspective, the dynamic that exposes these museums to that risk. And I think it'll be a fascinating topic this afternoon.
I mean, I agree with Mark 100%. And I think the dynamic that he points to is a really interesting one that was what got me thinking about the de facto effects of the de-accessioning rules, kind of the classic de-accessioning rules promulgated by the AAMD, saying that that museums can't de-accession for the purpose of generating revenue, which have the practical effect of saying that only private participants can take capital gains out of the art market. And I think that that's very much the dynamic that was at stake in the kinds of circumstances he's talking about, where the trustees of an academic institution look at the assets of the institution and say, hey, we have these extremely high value assets that we're not leveraging their value as much as we could. Why don't we take some of the value out of these assets and redistribute it to other parts of the institution where we can use those resources more effectively? And that means just selling artwork and taking the money, right? And that could be really good for an academic institution, especially a struggling one, right? And to say, no, you're not allowed to do that really forces you to ask the question, why? And also forces you to ask the question, right, who benefits from these rules that say academic institutions can't take the value under those circumstances?
I think Mark is right too, that in a way, you know, the perspective of a board member of a museum is really the same as the perspective of a board member of Brandeis University. As we all agreed earlier, the duty is to the larger mission of the institution. When the art collection is one small part of a larger ecosystem, like at a university, that's a little more obvious to us. But really the same analysis applies to when it's an art museum. If you're a board member, you should be thinking about how the collection fits in, treatment of the collection fits into your larger mission as you as an institution define it. But legally, I think the fiduciary obligations are perfectly parallel.
And I would just add to that, I think certainly one thing that Brandeis highlighted for a lot of people, which I think is understandable for lay people who are volunteering their time, is there were a lot of overseers, I don't mean Brandeis specifically, but there are a lot of overseers of university museums who think they are trustees, and they are not. Mm-hmm. And they play a very important role in the success and the management of the museum, but they don't actually have that legal authority, and perhaps by that same token, the legal burden that the trustees of the university does. And I think Mark makes a good point about, you know, endearment or communication or whatever else, which is to say the university, the board needs to understand the role of a museum in its mission, and that's on them. And I think the museum and its staff and its overseers or whoever it is need to advocate for their role within that mission to the board and to the president of the university, because it's part of the same picture, you know, as this is a lot of the same thing we're talking about before in terms of like, okay, how important is the survival of the institution in the way that it looks today to your fiduciary duty? You know, I'm a vocal proponent of liberal arts education. I believe very strongly in it. And I think when you start to shave off pieces of it, you really do violence to the point of it. So how do you balance those things? And I think from the outside, one of the things that happened at Brandeis is that just seemed to be so out of whack. I mean, it was literally a thought experiment. It wasn't, we have a Whistler, which is worth $15 million. We'll still have a museum and an art department, but we're going to refocus, and that'll enable us to keep having a French department. It was just like, no, out. So I think it's that balance. And I think each side understanding the role of the other, even when it's hard, even when times are tough, is going to lead to better outcomes.
Great, thank you. So I've got a bit of a personal question here, but I think it's a really good one to ask, which is, how do the panelists feel about the proliferating class of de-accessioning consultants and experts, of which they themselves are a part? Are they additive to the process and the field?
I believe in professional services. Yes. No. Look. I don't think I don't have a categorical answer to that from my own perspective. I think, you know, one thing I alluded to yesterday is, as the perspective on this shifts, and it has, you know, the market is going to react, and where the market goes, consultants to the market will follow. So I don't spend a lot of time thinking about whether that's good or bad. other than the larger outcome. So I don't know.
I mean, I would say that I'm technically a retired lawyer, so I'm undercutting the market by only providing legal services for free. I have a thriving pro bono practice. It seems like clients really like that particular pay scale for an attorney. But I'll confess I do most of my advising in the form of academic articles. So they're available to anyone who wants to read them, whether it's a museum or not.
I didn't know there was such a thing as a de-accessioning consultant, so I'm a little behind the curve.
I mean, and we're all professionals. We're asked to explain the law to people, to give them their options, to explain what the consequences might be. Yeah, we probably all have our own personal thoughts on the various issues that involve de-accessioning, but and I think there is some doubt about this in the public, but I think all of us give our dispassionate advice. That's what our clients are owed. And that's what they get. And our personal opinions, believe it or not, have nothing to do with the quality or the content of the advice we give. And shame on us if it did.
I've got a question here that veers a bit away from de-accessioning. This person says, I would love to ask the lawyers, to what extent museums have a legal obligation to make sure works in the collection are authentic or by the artist they are attributed to, perhaps insofar as claiming insurance value and that sort of thing. Does that responsibility fall to the museum?
I think yes. I mean, I think that falls to however the board delegates it. And the board should have a collections committee. And as I was saying before, that's part of good governance to have a process that's clear and prospectively applicable about how to assess these things. And I don't think the board is any more than a prospective buyer. I mean, we all litigate about this a lot, but put to a duty of perfect knowledge as to the authenticity of something. I think they are obliged to behave reasonably under the circumstances, to investigate what it appears to be and where it came from, whether it looks like it's too good to be true, and to follow that where it goes.
I mean, I think that's right. There is a distinct attribution right that applies to works of visual art. So when it comes to attribution, there's at least the potential for legal liability for misattribution or non-attribution as well. So I would say, that's certainly something to be aware of. And more broadly, I would say that Vera rights and sort of thinking about Vera rights or the moral rights that attach, especially under the Copyright Act, to works of visual art, which constitute often a significant portion of what ends up in museum collections, are something that, in my personal experience, museums and other arts organizations would do well to think about more programmatically, because very frequently they engage in activities or commissions and so on that do in fact implicate Vera rights of artists who they're commissioning works from without realizing that those rights are attaching. Thankfully, I've never seen that turn into a problem yet, but boy, did it ever come close a couple times, even in Lexington. So, that's certainly an area where I think museums would be well advised to take those issues seriously.
That's a really good point, Brian. I don't know if any of you saw, but there was just a decision in the lawsuit against Vermont Law School. I didn't actually read it. I don't know if it dismissed the claims but essentially ruling that the law school had the authority to obscure it from display. But that commission was not that long ago. In the span of an institution's life, that commission, obviously has led to a disagreement that is being litigated now. So that's a really good point well taken.
I'm really sorry to everyone, but my wife informs me that I must go get my vaccine poke right now. So so much, and I'm very sorry to have to leave early. Bye-bye.
That is an excellent reason to leave. Thank you so much.
We have de-accessioned him from this panel.
When you get a vaccine appointment, you've got to take it. So that's fantastic.
Always a balancing act.
So back to the question of de-accessioning, we actually have, it's so interesting how the questions are kind of coming in kind of thematic groups. And we've got a few here about de-accessioning for collection care, aka operating costs, as per the Baltimore example. There's a number of questions here that are around, as this becomes the norm, how does the panel think that FASB and the IRS are going to react, are going to deal with this?
Well, yeah, I think we need to distinguish between the reasons for de-accessioning and the use of the proceeds. I don't, it's not an acceptable practice to de-accession for direct care. The regents in New York do not, the Board of Regents do not include it among their reasons for de-accessioning. So we're talking about the use of the proceeds of de-accessioning, and direct care is, even in the state of New York, is one of the appropriate uses. So you can de-accession to refine the collection, and then you could use the proceeds for direct care. In 2019, FASB changed its standard. And just for those who may not know, FASB has a standard that requires museums to list the value of their collections at full and fair market value, which has all kinds of mostly negative implications for museums if they don't have rules that limit the proceeds of de-accessioning. Until 2019, FASB, the only part, you were limited to acquisitions. In 2019, it got extended to direct care. So FASB and AAM, as we talked about at the last session, are aligned in allowing direct care. AAMD is not yet aligned except for the 2-year moratorium. So I guess the answer to that question is how much FASB's rule matters to museums, to what change there might be. And my view is it matters a lot to museums that if they comply with FASB, they don't need to disclose the value of their collections. So I think, and again, we discussed this at the last session, I think the outcome is going to be that the definition of direct care will be expanded so that the rule itself won't matter as much.
I think that's right. And I mean, I don't think any of this is going to cause the museum an unrelated business income problem from the tax perspective. So I don't think it changes that.
Great.
Again, museums are already selling work. So
Right.
FASB has been in the past and can be amended to reflect the current practices.
So I've got one here that is kind of interesting in that it isn't actually, it just popped off the screen. There, I found it again. That it sort of isn't, it was actually phrased as a comment rather than a question, but I do think there is a really interesting question in here, which kind of goes more after, as legal experts, it's more of an ethical question, but it's about, it was referring to the Baltimore Museum example, and this person says they support progressive de-accessioning, but question the choice of objects being solely based upon what fetches the highest price. And so the question that's coming through here to me is, what do you think in terms of a legal or perhaps ethical judgment? Should these be based on curatorial choices, works that simply spend most of their lives in storage and aren't shown, or is it actually about monetary value of the works that are sold? And where do you find that balance in terms of what is justifiable in terms of kind of curatorial ethics?
I kind of see it as a combination, right? Which is to say, the question of how much money do you want to raise for a specific initiative is one question, but another question is, what do you want to be when you're done? And that question can be answered in lots of different ways. And I think one of the things that's challenging when people start talking about sort of as a point in favor of sort of less scrutiny or less concern about deaccessioning, the proportion of objects that are displayed relative to the proportion of objects that are not. A large collection of things that rarely see public exhibition is a perfectly valid mission for an institution, right? It may be the place where that kind of thing is stored and can be studied because it's got its own critical mass. Those things might have very little financial value or marketable value. So I think if, as long as you're thoughtful about what you want to be when you're done, and you're not, one of the sins of a fiduciary is wasting the assets of the principal of the thing for which you hold them in trust, or a nonprofit corporation. So you're safest when you're thoughtful about it, and that doesn't just mean, I think, the highest dollar for one initiative, unless you were turning that into the entire mission of your institution, which is a really different process that I don't think a board has the authority simply to do in many states without some involvement of the Attorney General, if you're really taking a complete turn.
I think that's a fascinating question for a number of reasons, because frequently one of the criticisms of a particular de-accessioning would be, well, you went for value, the monetary value, when you chose to de-accession. You didn't go into storage. You didn't, you took the most valuable thing you had. And and at the same time, many of those same people are saying you shouldn't look at the value of something in your collection based on what it would bring, what it's worth, but what value it adds to the collection. And they're in conflict, they're in tension, because if you sell the most valuable thing in terms of money in your collection, it doesn't mean that your collection has been diminished. It may have actually saved you. You could dispose of this one object that's worth a whole lot of money because that's what the market says at the moment. Or you can dispose of 3,000 other objects from your collection that brings the same amount of money. And people will criticize you and say, well, you sold the most valuable thing, not realizing if I didn't do that, I had to do this. And I think it's up to boards, and with the advice and the involvement of their professional leadership, to say, as we've said many times before here today, what contributes most to the mission? Does that one painting contribute most to the mission, the one that's worth the most dollars? Or is it the 3,000 other objects that we'd have to give up and sell those if we didn't sell the one painting? So that it's a very interesting dynamic as you look at that, and everyone gasps that you're selling the most expensive thing without thinking about you may have actually saved your collection in the process. And I think the other interesting, and I've challenged not just museums, but other people to look at this, and that's, I think, what the lost opportunity cost. You say to a board, okay, you have a $15 million painting. If you had $15 million today, would you buy that painting? Or would you do something else with that money? And unfortunately, universities look at it the same way. And museum boards can look at it and say, well, gee, if I had $15 million, I would use it to bring diversity to the collection, or would I buy this one painting? And museums kind of make that decision every day with the contents of their collection.
A related question, I'd be curious to hear what Mark and Nick think about this, is once a museum decides to sell a work, do they then have a fiduciary obligation to sell it at auction and get the highest price for it? Or could they, consistent with their fiduciary obligations, say, to keep it in, going back to our first topic, the public trust, we will only sell it to other public institutions, which will mean we'll get less money for it because we're restricting the potential universe of buyers. But we think that's more congruent with our overall mission to the promotion of art. Does either of you think a board member or museum could face legal challenge if they once having decided to sell something, don't put it up for the highest possible financial price?
I don't think they would. I mean, the question is who would object and on what basis? And, as I've proven, it's going to be the Attorney General, if anyone. And I think if there's an articulated balancing between the financial value and something to do with the intent of the donor in the first place, or the work of art relative to the original mission and its accessibility to the public, I have a hard time imagining an Attorney General really being too upset about that, unless you're literally just giving it away in a way that shortcut an effort to balance the two to get some value, some meaningful percentage of its auction or market value as compared to the other priority. So I don't know, Mark, what do you think?
Yeah. Well, Nick and I were on a panel yesterday with two heads of public charity divisions at New York and Massachusetts Attorney General's office, and the question came up, and I think if the audience is interested, they could look at the Jamestown Library case, and I know that's a library and not a museum, in the state of New York, where the Attorney General there said, no, the paintings that the library owned that it needed to sell to keep itself functioning had to go to public auction and not be sold to a group of local citizens who wanted to keep them in the town. So, and I would be wary advising clients to sell things to keep at less than they were worth to keep them in the public domain without advance approval from the Attorney General's office, because I believe the fiduciary, you go back to mission. If your mission is to keep art in the world, absolutely, you could sell it for less than it's worth because it's consistent with your mission. If your mission is to provide access to certain opportunities for the people of the city of Ithaca, and you sell a painting for less than it's worth to somebody in Arkansas, I think there's a potential breach of your mission. In a case like that, I think I would run it by the Attorney General first.
That also goes to a question Emily kind of teased at the beginning that we never really addressed. Who is the public, right? So Brian mentioned Baltimore. I mean, are those works, if you accept, whether metaphorically or literally, that the works are held in the public trust, are they held for the public of the city of Baltimore, the state of Maryland, the United States of America? So if they were sold to a museum in Arkansas, hypothetically, would that be a violation of the public trust because it's the wrong public? None of these things are really sharply defined.
And I think, so that's a really interesting, kind of speaks to a question that came in, which is about collections management policies. So, not specifically mission, but falling under that kind of broad picture of mission, which is a question about how diligently museums are required to follow their collections management policy in terms of accessioning and de-accessioning. And this person says, curators often are fond of saying it is a guide, not a straitjacket. But then yesterday, somebody said that museums are bound by it. What do you think? And I think this plays in with the question of the public and what is in that collections management policy that provides guidelines for what museums can and cannot do with their collections.
Well, I mean, having been a trustee, I think the collections management policy is both for the benefit of the institution and the protection of the trustees. Because if you have a collections management policy and you don't follow it, then I think you have more to answer for in terms of why did you do a particular thing. And if you have a policy and you follow it, then you're insulated against accusations that you didn't put the institution's interest first. So I think they're very important. I'm a lawyer, so I usually advise people to follow rules, but I think they're very important, and they're also just a good idea. If the collections management policy isn't working for the way your museum needs to do things, well, then talk about the collections management policy, I think.
I think Nick's absolutely right. And it was Jim Sheehan from the New York Attorney General's office yesterday who raised that very issue and said, we look to see if the museum or any institution has followed its own policies. So, I mean, Nick's right. And then it becomes a question of, and who's going to know? And that's never a reason to do something. Nick's right about that also. But I think the only way it comes up is if you get in trouble and the AG's office comes in and says, well, did you follow your policies? That alone is a good reason to follow them. But that's the circumstances under which you would, according to Jim, and I think he's right, that's one of the things the Attorney General's office would look at is, have you followed your internal policies?
Great. Well, we don't have a huge amount of time left, so I'm trying to sort of combine questions. We've got some questions around a few that are related about how much latitude heirs or estate representatives have to impose new restrictions or else to remove restrictions from donated objects, especially if the language is somehow ambiguous. And how might museums navigate requests for de-accessioned objects to actually be returned to a donor or to their descendants or heirs?
Well, from the legal standpoint, to change the relationship, you need what we call consideration, right? The donor, if the object's already in the collection and they say, we'd like you to do this or that with it, the museum can follow that if it wants. The simplest way always is to impose a condition on it when it's given. If the museum is willing to accept that, and if the donor wants that. If the object or objects are already in the collection and the donor or the heirs would like them to be treated in a certain way or not de-accessioned, then you probably need to sort of bargain and sign a new enforceable contract. I don't know if that was quite the question.
Always easy to remove restrictions. It's much harder to add new restrictions later on.
Yeah.
Interesting. There is, so there's a request here for a bit of clarification. So this is going back to fiduciary responsibility. So it says, is the responsibility of the institution to try to get the highest price under the assumption that an auction will yield the highest price? Or where's the balance between just the necessity of selling the object publicly for the sake of transparency? What is it about? I suppose that it seems like this person is just asking kind of for some clarification around that kind of tension between and what the responsibility is.
So I think the safest route for a board, if they're going to dispose by sale, is to sell at public auction. It's clear, it's getting the highest value, it's being sold in a totally public way. We're letting the market decide what it's worth. I think the real challenge for boards is when in advance of that, they receive an offer, and it's a private offer, and have to struggle with figuring out, okay, this is enough money. It looks like a good amount of money. Do I take this, or do I take what might be behind door B? And there's no easy answer to that. I mean, appraisals might give you some advice, some comfort on that. I don't think I would sell at private sale without some kind of documentation of value that I could show to an attorney general. But, it's not hard to get appraisals or, valuations that are within a pretty wide range. So you could certainly justify doing that, I think, assuming it's a valid third-party sale. But I think a lot of boards will take the conservative route and say, we need to do a public auction. It's the most transparent. The market will determine what it's worth, and maybe we'll get less, but it's safer.
The request for clarification is understandable, because I think we all agree there's no clear answer to this under current law. There's no case that I'm aware of that addresses this. I think the consensus was, as Mark said, the safest thing is probably auction. But if a museum or an institution wanted to go otherwise, the second safest thing would be to consult with the Attorney General first before proceeding.
And it may be a matter too of a judgment call about the medium and the artist in question, right? I mean, if you're proposing to sell a Rubens, you could get a meaningful appraisal based on comparable works of art. If it's a newer artist or whatever, it may be harder to do that and to document in a way you're comfortable defending that this appraisal, this private sale was in fact, a reasonable estimate of the market value.
Wonderful. Well, we're coming close to time. I thank you all so much. It was clear to me in seeing questions and comments go by that I think you've really spoken, especially to a lot of smaller institutions, was really clear to me, who you know, are wrestling on these, perhaps don't have, you know, the privilege of access to lawyers all the time built into their budgets, and I think this has been incredibly helpful on a lot of these questions that museums of all sizes and all budgets are dealing with on a very regular basis. So thank you for that. For everybody who is watching, thank you for attending this session. I want to point out yet again, next session, there are 3 choices. They are on pages 11 through 13 of your program, so you've got to pick one. And the next 3 sessions include the one we referred to in this session, museums with parent organizations. So talking about university museums and their unique situation. Likewise, historic sites and the de-accessioning dilemma, or is it? Which looks at historic homes and all kinds of sites that have unique collections, unique questions, and how they are dealing with them. And then finally, there is the Ask the Auction House, which is similar to this session in that it is primarily focused on questions from the audience, but you will be able to ask representatives from various auction houses about their perspectives on these issues. So that is coming up next, and we look forward to seeing you back in about 15 minutes. Thanks very much.
Thank you.
Thank you.
Thanks, Emily.
Thank you.